In a previous video, we defined what the two elements are that make up a DUI and what the state has to prove beyond a reasonable doubt to reach a conviction. In this video, we'd like to define some of the terminology used and some of the words used so that you can better understand what those elements are. So the first element is a vehicle. So again, in Florida, a vehicle is defined as any device upon which a person or property may be transported, drawn upon a highway, and that does not include personal delivery devices, mobile carriers, and things like that. So cars, motorcycles, motorized scooters, golf carts, things like that, that is a vehicle. Being on foot, being on roller skates, things like that are not vehicles. So when you're looking at your case, again, 9 times out of 10 or even more, it's going to be a personal vehicle, car, motorcycle, but just make sure you understand what a vehicle is. Second is, the state, again, doesn't have to prove you're drunk. They don't have to prove you're high. The state merely needs to either prove you have an unlawful blood alcohol level or you're under the influence to the extent your normal faculties were impaired. Well, what are normal faculties? Again, these are defined for a jury in the instructions, and they are including but not limited to your ability to see, hear, walk, talk, judge distances, drive an automobile, make judgments, act in emergencies, and generally to normally perform the many mental and physical tasks of our daily lives. There's actually a case in Florida, Shaw versus State, out of the 5th District Court of Appeal, which impairment means you're diminished in some material respect. So again, leave it to lawyers to define something that's still a little bit vague, but they don't have to prove that you're very impaired, even mild impairment. If a jury determines that mild impairment exists, then that satisfies the element of impairment for a DUI. We talked in the previous video about actual physical control, but again, I want to make sure everyone understands you do not have to be driving in Florida in order to get a DUI. If you have crashed the car and you're the result of the crash and the police show up and you're standing next to the vehicle and make sure they know that you were the one that was driving it and you're impaired, you're going to get arrested for a DUI even though you're not driving at the time. If you're sleeping it off, if you're passed out in your car, if you're passed out at a red light, if the car's on, if the car's off, if the keys are in the ignition, if the keys are in your pocket, if you're in the driver's seat, whether the car is on or not, and you're under the influence of drugs or alcohol, that means you have the ability to readily drive the vehicle. That's what actual physical control means. Now, if you're passed out in the front seat, and the keys are out of the ignition and they've been thrown out the window and they're 10 feet from the car, well then you don't have actual physical control of a vehicle. So depending on your ready ability to operate the vehicle or that you are operating the vehicle, the state must prove that element beyond a reasonable doubt to prove a DUI against you. The final thing to go over is a presumption of impairment. So when it comes to breath alcohol levels in Florida or blood alcohol levels, depending on what the level is, the jury will receive an additional instruction. If your blood or breath alcohol level is higher than the state limit, which is 0.08, a jury would be told that there's a presumption of impairment. It's rebuttable, meaning other evidence can suggest why the number is wrong, why the person is impaired, etc. But this is one of the rare cases where the jury is actually instructed to presume that that element is met based on the evidence that's being admitted in. If your blood or breath alcohol is a 0.05 up to a 0.0799, a jury will not give any instruction. They're not directed to think you are or are not or make any presumptions in the case. If you have a blood or breath alcohol between 0.000 and 0.049, you would actually get a jury instruction that would direct a jury to presume the person is not under the influence, that they are not impaired, but again, it is rebuttable. So some people have one drink and they go a little loco. So if that happens to be the instance in the case, just because you blow under does not mean that you cannot be found guilty of a DUI or that police do not have probable cause to make an arrest. I can tell you from experience, if the police think you're under the influence of alcohol, and they arrest you, and they take you to the jail, and you blow under, even if you blow a 0, you are not unarrested. They do not apologize and take you back to the scene and let you go. What they will then do is ask for a urine screen to test for drugs, and you are still going to be processed, and you're going to have to wait to make bail and be released. Now, the case may be dropped later, They might reduce it to reckless driving, careless driving, drop the case in its entirety, but it is not an affirmative defense that the case must be dismissed outright simply because you blew under the legal limit.